Chapter 6, Intellectual Property. Part 2A, Overview of Copyrights. The learning outcomes include: review major copyright principles according to relevant U.S. laws, explore the rights that copyright protection provides to its owners, describe copyright infringement and potential penalties associated with unlawful use of copyrighted materials, discuss protection that copyright provides to databases, evaluate the usefulness of copyrights as protection for software and/or mobile apps. Incidentally, notice the Cengage Learning copyright at the bottom of the slide. Although I've modified the slides significantly and they don't look like the ones Cengage provided, I still keep the copyright notice there. Let's start with a little background on U.S. laws as they relate to copyrights. U.S. laws on copyrights originated in the early 1900s, and the code has been changed many times to address new issues. Copyright is always behind the leading edge of technology, however. If granted a copyright, the owner has exclusive rights on how he or she may use the IP. Rights are limited only in a way that encourages competition or benefits society as a whole. This goes back to our discussion of the attempt to balance competition with encouragement of innovation. We want people to spend the research and development dollars needed to develop a new, exciting, and emerging technology. Intellectual property protections offer a payback for research, development, and creativity, and encourage competitors to invest in those areas. Copyright protection is described in detail under the laws of the U.S., specifically Title VII. Works that may be protected include, quote, original works of authorship, including books, performance, and music and artistic work. Copyright law is relevant whether you publish the work or not. It's your choice to do what to do with your intellectual property. You also don't have to seek a copyright for it to have copyright protections. But if you want to sue someone for infringement, you must have registered it. It's inexpensive, and you should apply for a copyright if you want to protect your investment. Clearly, copyrights only protect the expression of ideas, but not the idea themselves. Society owns the ideas, while people decide how to express the vision of society. Distinguishing between ideas and expression is often difficult. We are encouraged to build upon the work of others, but we must use care that we are using our own way to express the idea. Copyright law does not allow for protection of concepts, facts of nature, math equations or symbols, and so forth. While the idea is not protected, the expression is protected, even if the expression is not particularly creative, novel, or non-obvious. If a person seeks IP protection for product ideas, processes, or systems, she or he must seek a patent instead of a copyright. Copyright lasts for a limited period of time, depending on the country in which the work was copyrighted and the rules in place at that time. Often, copyright lasts for an author's lifetime plus 70 years. Then, or at some point, the copyright enters the public domain and is free to everyone. That's why some classics and literature are available free of charge online. If you legally get a copy of a copyrighted work, you may sell or transfer that copy. For instance, is it okay to give your textbook to someone for next semester? Yes. It's not okay for you to copy the book and give it to your friend and keeping the original textbook. Only the copyright holder has the ability to reproduce or make copies. Is it okay for you to sell your computer, including your copy of Microsoft Office? Maybe. You certainly can't keep a copy for yourself, but you must adhere to any license restrictions you agreed to when using the software. It's also acceptable to use a fair amount under certain circumstances. For instance, I can use a citation from a book for commentary and discussion. In education, if I put things behind a protected system for students to use, like D2L, I may use a publisher's material without infringing. Who determines if it's a fair use? If it goes to court, ultimately the reasonable judge and/or the reasonable jury of your peers. Of course, the reasonable judge and jury may not be as reasonable as we are, and is never a judge of our peers. You can take a look at this video that looks at the idea expression distinction. In the past, the important and profitable aspect of having exclusive rights through copyright was the ability to reproduce. You reproduced your book and sold it to people. You reproduced the Office CDs and sold it to people. The internet has changed the way copyright holders view their rights. It's the right to reproduce and share with fees or royalties or payment online. It's cheaper, more efficient, and easier for all involved to share online. It also allows the copyright holder a bit more ability to control who may have a copy of a product and if their license is up to date. Copyright also gives the copyright holder the right to create derivative works, although it's not always easy to tell if it's derivative or a new way to express the same idea. Copyright holders also have the right to perform the work publicly through singing or dancing or acting in a play, to display publicly in any form deemed appropriate, and to perform the work digitally, for instance on YouTube, or by recording the song and/or music. What about databases? For instance, what if you collected every name of every person in Cobb County and then put it in an online directory for everyone to use? Are the individual pieces of data, name, phone number, etc., protected? In U.S. copyright law, generally no, unless the selection and arrangement is sufficiently creative. Alphabetizing by last name, for instance, would not be creative. Even though gathering the names was a tedious, time-consuming task, the data is not protected. Instead, copyright owners may have to rely on trade secret laws and click-wrap licenses, where you click I agree without reading. You know you do it, and so do I. The EU does provide more protection for databases. If you do business there and want to know what is protected, you should get a lawyer who is experienced in the country where you plan to do business. Translating the database analogy to a website, a list of links is like a list of names in a printed phone book. However, say you want to read everything I've ever published because you just like my work. Then you rank the top 5 publications of mine and put links to them online. Since you creatively arrange the items in a top 5 list, it's likely that you may be able to apply for copyright protection. If, however, you wanted to list every article and proceeding and edited textbook and working paper I've ever published, and you put them in chronological order, then you're likely to have no protection. Again, the sweat of the brow that the gathering of information requires is not relevant to the decision of whether or not to grant copyright protection. For instance, a few years ago, David Brooks developed a website about Vincent van Gogh, his favorite artist. David collected every possible known work and put them online. Well, a website in the Netherlands duplicated almost the entire website. David had to try to defend his website based on the creative selection and arrangement of the items. This is a difficult argument to win. Ultimately, the Netherlands website was taken down. If a settlement was reached, it was not made public. Moral of the story is, make sure your intellectual property is a creative arrangement of ideas if you go the database or website route to disseminate information. Now we know about copyrights. When is there potential for the use of copyright as a suitable way to protect my intellectual property? Copyright is a viable option to protect software and mobile apps. It's cheaper to obtain than other IP protections, and it provides longer protection, often life plus 70 years for the author. However, Copyright only protects expression of an idea. Patents, on the other hand, may protect entire systems. And while copyright only protects against direct copying and does not protect against independent creation, patents do. We will discuss patents later in this chapter. To summarize, copyrights are a valuable option to protect the way ideas are expressed. If they meet the legal requirements, copyright ideas are protected similarly to tangible property. They are still one of the major options to protect software, although courts have begun to reduce the scope of what is protected. Copyrights never protect an idea, but sometimes it's hard to determine if the requested material is the idea or the expression itself. Courts struggle with this issue as well. Copyrights also do not prevent someone else from coming up with the same song, lyrics, or book through independent creation. Once the copyright is obtained, the copyright owner is responsible for protecting their IP and monitoring its possible misuse. It's usually wise to obtain legal counsel with dealing with any type of intellectual property. This protects your investment and maximizes your opportunity to profit from the expression of ideas.